let's start the meeting with the pledge of allegiance. As presiding officer of this regular meeting of, presiding officer of this special meeting of the West New York Zoning Board of Adjustment, I do hereby publicly announce that the notice requirements provided for in the Open Public Meeting Act have been satisfied. Further, I direct that this announcement shall be placed in the minutes of this meeting. Notice of this meeting was properly given by the West New York Zoning Board of Adjustment, and it was appropriately published in the Jersey Journal, publicly posted on the municipal bulletin board and filed with the town. For all those devotees of the zoning board, they will notice that Ms. Varilla, our board secretary, is not present tonight. She had an emergency, she couldn't attend. She called me and I granted her the exemption. Instead, we have our attorney, who gets paid the big bucks anyway, doing not only legal counsel work for the board tonight, but also doing the duties as board secretary. That being said, I'll ask Mr. Boris if he'll please call the roll.
Roll call: Alberto Chapin. Ramon Morihone. Jesus Alvarado. Rose Puerto. Kenneth Blaine. Elmer Martins. Mohammed El Maksud. We have more.
The first matter on the agenda is a continuation of Meridian Boulevard matter. I understand where we are at the moment is for the rebuttal by the applicant, and I see Ms. Puerto being proactive in the sense of moving from the dais where the board members are and recusing yourself. Yes, Mr. Alonso.
Good evening, Mr. Chairman, for the record, Alonso never read the applicant. That's correct. We have one rebuttal witness this evening.
We can't hear you.
One rebuttal witness this evening, John McDonough, planner, and another rebuttal witness is unavailable for this evening. And I also have all our witnesses presented to the board for questions. I would indicate that Mr. Pergoy was unavailable for this evening, and we do have another member of this firm, the traffic engineer, who's removed the file. So to the extent. So to the extent there are any questions with respect to the report, he will be able to answer them. However, if there are any specific questions related to testimony by Mr. Pergoy, there may be.
You're talking about questions by
The board, of our witnesses.
we may not get to that point.
Okay, my understanding was we were going to present Mr. McDonough and present our witnesses in the event of the board any questions.
I don't know.
I'll defer to the board, whatever.
Of course you will, and I don't know who gave you that opinion, but it wouldn't be my way of proceeding.
Okay, that's fine.
So, let me ask you first of all, as I understand it, you're going to present Mr. McDonough today as your only rebuttal witness. Do you have another rebuttal witness? What type of witness is he?
His firm designs parking structures. There was a lot of testimony and a lot of questions with respect to the parking layout, the size of the parking spaces, the aisle widths, and whether or not it operates properly. So, if you recall, there was
And when did you engage him?
October.
In October?
October. He was part of.
In October 2014?
He was part of the design team.
And
He was
on
never
April
out.
16th, you knew that the purpose of the hearing tonight was rebuttal?
Correct.
And he couldn't be here?
He's in New York. He's not local.
Don't they have telephones?
Mr. Chairman, all I can indicate is that he's not available.
I don't understand why he's not available. On April 16th, I mean, if you
you told me you engaged him yesterday, I would understand. If you told me you engaged him in October 2014, on April 16th, you understood the purpose of this hearing was to conclude this matter, with the first portion being rebuttal by the applicant.
Correct.
I don't understand why he's not here.
I was informed yesterday that you were unavailable.
Did you ask why?
I did not ask why.
So, that of course is a very awkward position considering everything that was said on April 16th. You understand?
I understand that, but
Well, I'm glad you understand that.
But unfortunately, this has become an event. That's unfortunately, that's what
Okay,
happens.
how are you for Thursday, May 14th?
Yeah, I indicated to Mr. Waters that I have another application rescheduled in another town, and likewise, the witness is not available on the 14th. The email that he sent me is the earliest he's available is May 28th. I asked him to please provide me with additional dates earlier than May 28th, and I wait for a response.
Oh, I'm sorry, the dates earlier than,
Then May 28th. I responded by email to please provide me with earlier dates than 28th.
because I'll tell you that if that is the case, that he can't come until April 28th, and he was engaged in October, I'm gonna look for a attorney to find out what we can do to conclude this matter without. I'm just telling you, that would be the way I would proceed. I mean, there's a certain amount of leeway, I suppose, that this board will have, considering that you're now causing the delay, or the postponement, the postponement. But I guess there's a line that I personally feel, and I don't know if legally we can draw it, but I'll certainly do everything I can for a attorney to find out if that's possible. If we can do it prior to the 28th, closer to the 14th, I would appreciate that, assuming that, let's find out when he's available. Because if we find out when he's available, as well as all your other consultants, because that's when the board wouldn't have to be asking questions after his, in other words, it would be your rebuttal tonight, you would end your rebuttal whenever the special meeting is. I mean, that would be the appropriate procedure. Then you would go, then I guess you would do, then I guess the board would ask their questions at that point, as opposed to feasting. Then you would do your summations, and then the board would make a decision.
Correct.
I mean, that to me would seem to be the reasonable procedure, as opposed to the board asking questions tonight, and then asking questions then. All right, all questions would be at one meeting.
I have no problem with that.
All right, so why don't we find out, when, your traffic, parking, space, dimension expert is available, and we'll try to schedule a meeting for that date. Yes, Mr. Kennedy?
Good evening, Mr. Chairman. Would it be appropriate, since this gentleman was part of the team, engaged back in November, to find out his availability?
Well, you can do something.
Very yes. Very yes.
Jerry Giassi. Mr. Alonso can email you his, I guess, his name and whatever tomorrow.
GIA, sorry.
Well, let him send you an email tomorrow. To me, that's not a big deal. Okay, I thought we would have a special meeting on the 14th. I guess we can't because, this person is available. So we'll just have to wait and see. Mr. Alonso, when are you going to know that the years ago?
What I'm gonna do is, questioning who's gonna done it, have somebody else on the team try to reach out and get that information, so.
Okay, so the least we can do is possibly set a date tonight. And then we'll worry about where. Well, I guess we can't.
Hear a word.
I said, we have to have the date and time and place available unless we have the applicant renotice.
Well, we can get a date tonight, correct me if I'm wrong, we can set the date for this courtroom. If we have to move it from this courtroom, we can put notices up to move it, or we would have it on that date.
Chair,
Yes,
you might want to just ask people, what you might do is, at the end of the meeting, the date, time certain is not known, or communication, is simply continue it to the date and time of the board's choosing. If it turns out the gentleman is available, let's say the 28th, fine. If not, the 28th or sometime prior.
well, the 28th is our regular meeting.
I understand that, but I'm just simply saying, in order to obviate the need for them to provide additional notice, I'm confused.
No, I'm not looking for that, we would make the announcement tonight.
But you need a date certain.
Yeah.
Well, I understand that, but Mr. Alonso's gonna try to find that out.
I'm just saying, if it doesn't happen, you use the 28th as a placeholder.
Thank you, Mr.
There's an added issue that Ms. Varela is not here tonight, and she's the one that has access to this room's calendar. So,
So we're somewhere between, regular meeting on the 28th and doing something closer to tonight. Noting this space, and if it's not available, posting notices for where it will be available, for instance, the library or somewhere else. But at least to get, our goal accomplished, resolving this application. Okay, so why not, on that note, why don't we continue with this meeting? And this is. Why don't we take a 3-minute break because the board members want to vote?
Travis and Pascal.
This is Ron Sherman. This is Josh Richardson.
Okay, we all settled? All right, why don't we start with Mr. McDonough's rebuttal? And, please speak into the microphone, members of the public who would like to hear. Mr. Alonso, I can also tell you regarding your other consultants, questions will not be asked tonight. It's up to you whether you want them to stay or not. It's up to you.
Right, I don't believe it's.
Oh, what he was talking about is addressing the date issue, with the consultants, that's why he's not having them leave at the moment. Please continue, Mr. McDonough.
Thank you, Mr. Chairman, members of the board. Can everybody hear me back there?
Excuse me, can I say something?
What?
There are some Spanish people over here that don't own that in English.
We do not have a translator, I'm sorry.
This is supposed to be. It's supposed to be
No, it's
some
not.
translator here.
I'm sorry.
Because there are some Spanish people here that don't understand English.
Mr. McDonough, you were previously qualified and sworn in. I'm assuming that your qualifications haven't changed, and I believe you should still be sworn in, unless you need to be sworn in again.
Do you need my name? John McDonough, MC.
Totally ready. Do you swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. McDonough, you were present to pretty much all the testimony,
Yes, I was.
okay, and you heard the comments from the objectors as well as And you heard the comments by the objectors as well as.
Mr. Arcivia and others, if you want to have a conversation, please step outside. The stenographer can't hear.
Thank you, Mr. Chairman. Okay, so you heard the comments from the objectors as well as the testimony by Mr. Rainkamp, the planner hired by the objectors, correct?
I did, correct.
Mr. Alonso, please speak in the microphone. I'm not sure the public can hear you.
Thank you.
Okay. One of the big issues that was raised through their comments was the impact of the proposed building to the pool in terms of the shadow. One of the residents indicated that the pool was built on the north side of the building because of the sewer treatment plant, which was located on the south side of the building. Is there any testimony you can provide with respect to that issue?
Well, I went back and looked at aerial photographs, and I don't know that it's conclusive that that pool was constructed on the north side as a result of the sewer treatment plant on the south side. Mr. Chairman, if I may, I have some additional exhibits to enter. They're just downloads of aerial photographs to document what I found when I looked online.
Okay, so I'm just gonna mark them as A9.
And there are two photographs, they're 8.5 by 11. One was taken in 1979, and one is of recent vintage.
Okay, so please identify what A9 shows.
A9 is an aerial photograph showing the subject site in the middle of the photograph, again circa 1979, downloaded from a historical aerial website.
Okay, and we know from the testimony that the Versailles was built in the 1960s sometime.
Correct, and the point I'm trying to make with this visual is simply that the board will see the Versailles building is there, the pool is on the north side, there are no treatment plant structures on the south side, immediately adjacent to the building. They do show up in the second exhibit,
Just A10, and just identify what A10 is.
which is downloaded from Google Earth. And again, this is of recent vintage, showing that there are structures on the south side on Anthony DeFino Way.
Okay, and so currently there is no testimony, other than that position with respect to the existence of this treatment plant. There is no other reason stated on the record that you're aware of as to why the pool was constructed on the north side of the building?
Correct. This just, for me, just brings into question the actual. Just picking me up, the actual intent of why the pool was sited on the north side of the building. It's just contrary to what we would typically see from a planning standpoint, put a pool on the north side, that's all.
So I'm just gonna provide these photographs and just pass them around.
Let's give it to our secretary.
And now there's also a lot of testimony by both the objectors and Mr. Rainkamp with respect to the applicant's obligation as to the affordable housing components. Is there any rebuttal testimony you can provide with respect to that issue?
Sure. As a point of clarification, the applicant never claimed that it would not comply with its lawful affordable housing obligations. The town's affordable ordinance is based on a growth share ordinance, which was similar to what we saw under the COA rules, the Council of Affordable Housing rules, that were just knocked down again by the courts in March, a little more than a month ago. COA being shut down as a result of that decision. The courts will ultimately decide your town's obligation, and most of the formulas that I'm seeing today that talk about what your prospective need will be, they vary, but the highest number is 0. Lowers as low as negative 721. I'm saying that you have a surplus of affordable housing of 721 units. So again, just to reinforce and to clarify for the record, the applicant has never claimed that it will not provide affordable housing based on its lawful obligation. To the extent that there's an obligation, the applicant will provide it.
And I believe that was the testimony during the hearing that whatever the lawful obligation is, we would comply.
Correct.
Now, there's also questions and comments with respect to our compliance with the RSIS in terms of the waivers and applications that need to be made. Is there any testimony to provide with respect to that issue?
Yes, again, the applicant has never claimed that it would not comply with its outside agency obligations in terms of procuring improvements on the county level, on the state level, inclusive of the NJDCA, which is the overseer of our residential site improvement standards, otherwise known as the RSIS. It's a typical condition that we see in a resolution of approval to provide approvals in accordance with outside agencies, and the applicant consents to do that as well. Bearing in mind, the applicant is not looking for a de minimis exception with respect to the parking supply. We comply with the ordinance, with the regulatory requirements in that regard. It's the ordinance that we're seeking the relief from. The applicant is seeking relief with respect to RS requirements for stall width and parking dimensions. And in that regard, we'll comply with our lawful obligation as far as DCA is concerned.
And basically, should this application be approved, we would submit it to the RSIS with a resolution of approval.
Again, yes, we will comply with our lawful obligation.
There was also an issue raised with respect to the time of application versus the time of decision. Of course, there's a new master plan that was adopted in 2014. What, if any, testimony can you provide with respect to that issue?
Well, I know that there was some legal wrangling in front of the board with respect to whether the new master plan does or doesn't apply. The key point from my perspective is that that master plan was adopted after I testified. I testified in October, the master plan was adopted in December. Nonetheless, the master plan does have some things that I would like to point out for the board. It recommends
Objection, this is not outside the rule.
This is the new master plan you're talking about?
2000, was it,
Mr. Kancowitz, your planner's testimony addressed the whole master plan.
Yes, it did, but
So-
let me be heard, if I may.
Okay.
You're the chair of the board, that's fine, I'm here. Mr. McDonough, and the board is aware, he testified on, I believe, September 18th, he testified. He was cross-examined on December 1st, and he was redirected by Mr. Alonso on January 22nd. January 22nd postdates the date you just adopted the master plan, number one. Number two, his testimony on the master plan, 2014, essentially is an effort to supplement prior testimony about the negative criteria. Because there's no other purpose to talk about anything having to do with the master plan, unless you're going to talk about negative criteria, unless it just wants to talk about the master plan, say talk about the plan. Therefore, this is testimony that was fully expected and should have been and could have been a part of his earlier testimony, either on December 1 or January 22nd, when he was specifically redirected. And I can pull out the transcript to show you that redirected. This was not an opportunity that was taken by the applicant at the time, and I make the argument, but I certainly leave it to the chair to make the call in his discretion. This is what rebuttal testimony is. Case law, and I understand you're not bound by formal rules of testimony, but I object on the record. Rebuttal testimony is designed to rebut specifically factual statements made by the other side's witnesses, and I did not object to the other prior two questions, specifically pointed to what this testimony to. But it's not intended to be repetitive, redundant, or cumulative. Essentially allowing Mr. McDonough to speak now to the master plan. And you can proffer the question to why is he being asked, why is he speaking about the master plan? Will simply be a second bite of the apple in what should have been his direct testimony.
I understand you.
That's my objection.
I understand you.
Well, the objection is actually longer than the response would have been. But with that said, the rules.
Right, you should talk. Mr. McDonough, what specific questions are you inviting by your discussion of the new master plan?
And here,
I'm sorry, Mr. Reddick.
Mr. McDonough, what specific questions are you rebutting by your discussion of the new master plan?
it's not a question that I'm rebutting, it's a statement that was made by the applicant's planner with respect to certain elements within the master plan, the 2014 master plan. And all I wanted to do was point out a few elements that were not pointed out. the master plan will speak for itself, and I'm just pointing out certain aspects of it.
All right, I'll deny the objection and let you continue for a period of time.
So, to the extent that the 2014 master plan does apply, the three key points that I wanted to bring out for the board is that the master plan does recommend the elimination of density provisions. Bearing in mind the applicant is seeking a density variance here under the current zoning. Also, the master plan recommends what I would consider to be more of a graduated FAR based on lot size, as low as 5 up to 15. This application, from a lot size standpoint, falls somewhere in between the 5 and the 15 in terms of the lot area size. So if we look at this from a sequential or progressive standpoint, again, from a purely factual basis, the density of 11.75 is on par with the difference between the 5 and the 15. And then finally, the master plan does contemplate high rises on both sides of the street. It actually talks about that, with a separation of 80 feet, which factually this building would comply with respect to its offset front and facade.
Mr. McDonald, let me just ask you, did the new master plan change the requirements?
I'm sorry. Let me just ask you, just off the top of my head, this is not really part of the questions. Did the new master plan change the requirements for the new building such that, is both recommendations, such that it reduced or lessened the variances needed?
The recommendations would
That's
lessen.
not the recommendations.
There's no zone plan that's been adopted based on the master plan.
All right, because when I look at the master plan, and it has the maps, I'm looking at maps that to me are identical to the old maps.
The zones have not changed, that is a correct statement. The zones have not. So the bulk parameters, the intensity of use parameters have changed from a recommendation standpoint. I don't want to mislead the board.
Right,
There's
so
no
as-
ordinance that's been adopted.
What I'm saying, as of today, the project is under the same requirements since they haven't changed
Exactly.
as they were in the past. So the board doesn't get confused, that's all.
Correct.
Thank you very much for your clarification.
Mr. McDonough, Mr. Rainkamp also provided testimony that given the number of C variances, it could actually be equal to a D1 use variance. As a planner, have you ever heard that before? Have you ever seen the case law to support that before?
As a practicing professional for 25 plus years, I am not aware of that. I'm not aware of quantitative analysis whereby the number of variances would elevate what would be C-level variances up to D-level variances. That means the applicant has a higher burden of proof. I've never encountered that before. I don't know if in case law or I don't know anything in the statute that talks about that.
And finally, there was an issue raised by Mr. Rainkamp with respect to a D3 conditional use variance being required in this application. What, if anything, can you testify with respect to that issue?
Objection outside the scope of his Raincamp's examination. I believe counsel conflated this hearing with the last time.
No, but Mr. Rainkamp actually testified that if you look at the exhibit at the back of the zoning ordinance, it says permitted uses and refers you to a note. Go to the note and there are conditions. He equated that to a conditional use variance. And I said, well, no, there's a specific section which is conditional use is permitted in the zone. That would be a conditional use. So that was Mr. Rainkamp's testimony.
Mr. Chairman, my recollection is Mr. Rainkamp did indeed use those conditions in describing the chart, but I don't think at any time, unfortunately, I did not have the transcript of that community hearing, did he ever equate or make the jump that the conditions enumerated created a conditional use, which is a term of art.
That being the case, I don't see how Mr. McDonald is going to answer this one.
That being the case, I don't see how Mr. McDonough's answer would be partial, so please answer.
So the question was, is this a D1 variance or a D3 variance as a pure use variance or a conditional use variance? the structure of your schedules. Mr. Kantorowicz walked me through them, that this use is in the column of permitted uses. There is right next to it a column of conditional uses, and this use does not land there. That's my concise response.
So in your opinion, a D3 conditional use variance is not required?
Correct.
Mr. Chairman, I have nothing further.
Mr. Kantorowicz, do you have
Yes.
any?
Yes, just two questions, thank you.
Why don't you change places? Make it easy. All right, don't make it easy.
I'm good.
Sorry about my back.
Mr. McDonough, you're familiar. Can you hear me? Mr. McDonough, we talked about when I cross-examined you, I believe in December, I asked you some questions about the West New York zoning ordinance that spoke about an affordable housing obligation. You familiar with, you recall I asked you about the West New York zoning ordinances?
I do.
Speak to that. And you testified you're familiar with the West New York zoning ordinances, okay? Is it your understanding that that section of the West New York zoning ordinance that prescribes an affordable housing obligation in conjunction with new construction has been repealed? Do you know? Has that section been repealed?
I don't know.
You don't know whether it's been repealed,
I don't know.
but you stand here as an expert telling us you're familiar with the applicable zoning ordinances of West New York.
Yes.
Okay, and is it your belief, if you don't know whether it's been repealed, let's assume it hasn't been repealed for the moment, is it your belief that it is a lawful ordinance? That's a yes or no question.
Yes, it is a valid and lawful ordinance
Thank
until,
you.
until challenged.
Okay? And let me show you. You testified a moment ago about RSIS, correct?
Yes.
Do you have any reason to doubt that Note B in Table 4.4 from the RSIS book speaks to a 0.5 spaces per dwelling unit requirement for guest parking? Any reason to doubt that? Are you-
No, I know that.
Okay, you know that requirement?
Yes.
Because you're familiar with RSIS, that it that, and you know that requirement? Okay.
I've lived it for a long time.
Okay. And let me show you something from New Jersey statutes annotated 5:21-3. I'm sorry. Let me show you something from New Jersey statutes annotated 5:21-3.1 exceptions, because your lawyer just asked you about the obtaining of an exception from the RSIS. And I'll read you section A. And it says, and I quote, little a, the municipal approving authority may grant by resolution of the planning board or zoning board of adjustment such de minimis exceptions from the requirements of site plan standards that may be reasonable, and within the general purpose and intent of the standards, if the literal enforcement of one or more provisions of the standards is impracticable or will exact undue hardship because of peculiar conditions pertaining to the development in question. Did I read that correctly?
Yes.
Okay. Now let me show you what's B, little b. Quote, an application for an exception pursuant to this section shall be filed in writing with the municipal approving authority and shall include, and then there's a colon and a list of several things that are to be included. Did I read that correctly?
Yes.
Okay. And you testified earlier that shall has a mandatory meaning in the ordinances, do you also concur that shall has a mandatory meaning when it's used in this kind of regulation?
I do.
Okay, and to your knowledge, are you aware whether a written application for an exception for RSIS has been filed with this zoning board in connection with this application? That's a yes or a no.
No, I don't know.
You don't know whether anything has been filed. Okay.
Thank you, Mr. Cantore. Thank you, I'm sorry. Okay.
Mr. McDonough, that section of the RSIS that was just read to you by Mr. Kampowitz, on the application for exception, does it provide a time within which the application must be filed?
No.
So can it be filed after this application were to be approved, if approved?
Again, I see no timing restriction.
Now, with respect to section 414-111, with respect to the affordable housing plan, it
Yes.
says that each affordable housing production plan shall be subject of review for consistency with COA's rules, the Fair Housing Act, this article, the Town of West New York Housing Element and Fair Share Plan, as proposed and or approved by COA, and such other rules and regulations as may be applicable. Can such an application be filed? Or can you get such a determination?
Can you repeat that for me, please?
Sure. Well, you can read it.
Okay, each.
In other words, are there any COA rules that you can comply with?
The answer is, you can't apply to COA because COA has been stripped of its authority as a result of that March decision.
And also, that's a condition for completeness with respect to this application. To your knowledge, has the applicant been served with any notice of deficiency with respect to that condition and completeness?
No, not at all.
Thank you, Mr. Minton.
Thank you.
That's your only witness tonight?
Yes.
That being the case, have you gotten dates from, regarding this, additional expert?
Maybe the police officer. Do you know what date the municipal courts, take place here? Well, it can't be every day because we're sitting here right now. Oh, I see what you mean. In other words, what is it?
day during the May session. Afternoon session, Tuesday.
Is it Tuesday? Tuesday. So Tuesday is the only night that they would use this? Yes, would you please? Thank you, I appreciate that.
Mr. Chairman, on the 21st of May.
That's all.
Alright, so in my acting as board secretary, I looked up this room we know is not available on May 11th because the planning board, May 13th because rent control board, May 18th because the housing authority, May 19th because the parking authority. Alright, so
May 21st is a Thursday. Let's do it. Now, let's do this, Mr.
used, I think Mr. Kent used the word repealed. One of the attorneys did, I did not.
Well, why don't you
COA,
clarify?
the courts issued a decision in March that effectively took the COA rules and made them ineffective or inoperable as the entity for enforcing the formula for affordable housing.
So it wasn't repealed, it's just not. Mr. Cantor?
Yes. Yes.
We can't hear.
If the COA rules were not repealed, or you, Mr. Cantwitz, do you feel that the COA rules were repealed by the court?
No.
No, he doesn't.
Let me explain, because it
That's what
requires.
Mr. McDonough tried, but go ahead.
And I speak gratuitously somewhere actually, as council, as one of the council's directors.
Okay.
Please hear you. What the court did on March 10th, 2015 was, as we lawyers say, it held that there was no longer a need or a requirement for any town to go to COA to have determined its affordable housing obligations. It said that requirement under the law is now done. You do not have to go to COA. COA is a moribund, dysfunctional agency. What the court then did, this is all in the opinion, is it said all affordable housing matters that would otherwise have gone through the state agency may now go through the courts, who will perform a function of processing affordable housing administrative processes through the courts, through the trial courts in the state of New Jersey.
When the issue was
And
brought before.
when the issue is brought to the courts. With respect to what rules they are to apply, the court reiterated what it had held earlier, that certain of COA's earlier rules were deemed to be not valid. Other parts of COA's rules were deemed to be still valid, and that trial courts, when faced or confronted by these affordable housing matters that are brought to them, will navigate their way through and determine what laws are and what applies.
Thank you, Mr. Cantor.
I hope that's helpful.
Mr. Chairman,
All right, have a good day.
Mr. Chairman. If we may, I also have co-counsel here who says it's additional information that should apply to the board. It wasn't a complete explanation.
Let me just state what I stated at the last meeting. And this is from a legal memo that I received as president of the Riviera Towers from one of our counsel, from one of our big-time law firms. My understanding is, essentially, there are no rules for COA. And let me say why. Because I understand what Mr. Kantrowitz said, and that's the backdrop when an action is brought before a court. But at the moment, it's my understanding that, and I said that activists or third parties or somebody have to sue the municipality to get into court for those things to operate or not operate. That's where we are. Okay?
And again, the testimony is to the extent that there is a lawful requirement, we will comply.
Okay. So the 21st,
Except there's a word.
okay, fine. Yes, except the 21st. Okay, we're now going to, oh, I'm sorry, police officer. Police officer. Yes, Sergeant Murphy's law. Okay, so what were you gonna tell me about municipal court? Tuesday only. Fantastic. Okay, we are now going to adjourn this matter to Thursday night, May 21st, in these chambers, starting at 6:30. The only thing on the agenda will be this matter. We will hear, I assume very briefly, because we're talking about sizes of parking spaces. Did I really say that? Yes, I did. From the expert, from the applicant's expert. We will then have questions by the board of all of the applicant's consultants. And Mr. Kantrowitz, I think maybe you should also have your planner here just in case, if that's possible. In case the board has any questions. Then each party, the applicant and objector, is being given 15 minutes of summation. Then the board's going to make a decision. Absolutely.
Since the applicant indicated,
Since the applicant
the applicant indicated that this new rebuttal testimony whose name and address I'll receive tomorrow by email will be coming, but was retained as far back as in October, I would ask you as the presiding officer to exercise your power under Municipal Land Use Law Section 10C and issue a subpoena.
or whatever I have in
Yeah,
here.
and issue a subpoena to both compel that intent. Let me finish.
Let's do it another way. Mr. Alonso, can we agree that if he doesn't show up on May 21st, that his testimony at that point in time will be waived?
I agree. That was half of my request.
Oh, okay.
The other request was that if there is any notes, documentation, or other papers that he prepared that are gonna.
Like a reporter.
Yeah, that we be provided with that, or in some fashion, whether it issues as a subpoena or Mr.
No.
Alonso
I just-
can give me representation so that I'm not being handed a document from someone who they've known about for months.
I would ask Mr. Alonso to give you that courtesy as a colleague attorney. You can call the expert tomorrow and find out if there's anything like that that Mr. Kentry was talking about, and have it scanned and emailed to you, and you can give it to Mr. Kentry. Is that? Okay.
Thank you.
Thank you. That being the case, the matter of Meridian Boulevard will be adjourned.
Keeping the applicant's consent to do a decision later, obviously the applicant requested this adjournment, so it's applied, and I just want to get it on the record, the applicant is
Well,
consenting.
Mr. Alonso, do you consent to the adjournment from tonight to the special meeting on May 21st? Mr. Kantrowitz, you consent to that also?
Yes.
That being the case, the matter of Meridian Boulevard will be adjourned until 6:30 in these chambers on May 21st. Thank you, everybody.
Thank you.